Ladies and gentlemen, welcome to today's webinar. Today's seminar topic is the state of professional guardianships in Florida, separating fact from fiction. Our presenter today is attorney Teresa Phillips. If you'd like a copy of today's presentation, you'll find it in the handout section of the webinar interface. Similarly, if you have a question, you can type it into the questions section of the webinar interface. And now let me turn it over to Teresa. Go ahead, Teresa.
Hi, thank you, Tony. Hi, good afternoon, everyone. I'm Teresa Phillips. I'm here at the offices of Forster Bowman. We're located in the Orlando area, just outside downtown Orlando in Maitland. Among things that I do here is guardianship and guardianship adversarial proceedings and litigation. Today's presentation is going to be on the state of professional guardianships in Florida, separating fact from fiction. So we're gonna do a little introduction into guardianship, but a lot of this is going to focus on professional guardians, especially in the context of those that are aged or infirmed and are incapacitated due to that. There are incapacities due to just being a minor. Most of those are usually, handled by the parents. There can be a professional guardian, but in most contexts, you'll find that it's in the case of an elderly person or a mentally infirmed person, and that's what we're going to focus on today and try to look into what's going on with professional guardians. Before I get started, I just kind of want to tell you why I chose this topic to speak on. I think it's pretty current right now. There's been a lot of publicity about what is the exception to the rule, thank goodness, but about abuses by guardians. The Rebecca Furley story has been very top of the news here in the Orange County area. And then there was just recently on a Netflix docuseries called Dirty Money. They featured some stories about some really bad abuses by professional guardians throughout the country. And so I think it's something that's on people's mind. Also, guardianships are booming. The Ninth Circuit reported just a few months ago that they're up about 33% in guardianship cases over the last 5 years, and they see that number rising. There's obviously an obvious reason for that is that the population is aging. The baby boomers are aging, but I think as a practitioner, I think a lot of it's being born from a system that still has some things in it that needs to be worked out to tighten up, so that most people today find themselves in the middle of guardianships. Maybe there's ways that we as practitioners, as advisors, maybe we can keep them from getting into that position. And I want to explore a little bit of that today as well. But let's start with with our agenda, shall we? Well, doesn't want to cooperate with me. There we go. Our agenda today, I'm going to do a brief introduction on guardianships in Florida, the basics, the nuts and bolts. Won't go spend a lot of detail on that, just set it up for our more substantive discussion, and that's going to be going into section 2, where we'll discuss professional guardians, what the pros and cons of having a professional guardian as opposed to just a personal person in that person's life serving as the guardian, a relative, a friend, something of that sort. We're going to look at potential liabilities and damages arising from when professional guardians do not adhere to the standard, and maybe even look and explore what maybe damages and liabilities could fall upon those professionals that advise these guardians. We're going to look at the need for pre-planning. It's probably the best way to avoid getting yourself in a guardianship that you don't want to be in, that's controlled by someone you don't know. Costs are out of your control, where decisions are being made by a person you don't even know. Those are goals usually people have in mind, and I think you'll see we'll look at what was available for pre-planning. I think it falls short in some ways, and we'll discuss that, but it's probably your best weapon right now, or your best tool you can use to avoid some of these situations that people find themselves in. And then we're going to go over comments and questions and answers, and I'll circle back to those cases I alluded to in the beginning and see how we can compare maybe what Florida law provides and how maybe it can be used to prevent some of the abuses that we're seeing by professional guardians throughout the country. Okay. I might turn to the next slide as soon as the computer decides to cooperate. So let's look at what rights, let's look at incapacity first. What is incapacity? In its most basic legal terms, incapacity can be due to mental infirmity or age. It's the legal definition of lacking the capacity, the ability to manage at least some of your property or to meet at least some of the essential health and safety requirements that a person requires from day to day. That's defined in section 744.102, subsection 12 of the Florida statutes. When you go, if you've ever been involved in any kind of incapacity proceedings, that's what the judge, that's what the examiners are trying to determine. Can this person make decisions about their financial wherewithal, their property? Do they understand enough to know what to do with the money that's coming in and how it should be spent? Do they even understand what they have? That's a common question that's asked. Do you even know what your assets are? And then can they just do basic needs, more personal side, not the business side of guardianship, but the personal side? Can you decide where you need to leave, what kind of care you might need? Can you get yourself to your doctors? Can you even make decisions about what doctors you should be seeing? Those are the kind of things that you're looking for when you're trying to determine if someone has legal capacity or not. It doesn't mean they have to make good decisions. It just means, do they have the ability to make these decisions? So let's look at different types of guardianships. The two main differentials are plenary and limited. Plenary means it's a full guardianship. It means in all aspects of your life, you need a guardian making your decision. The statutes and the case law and the public policy is to try to find the least restrictive means possible in these cases. So unless it's absolutely necessary, a judge doesn't want to strip a person of all their rights to make all their decisions unless it's absolutely necessary. And if it's not, that we have what was called limited guardianships. Maybe this person is having bad decisions, he has memory issues, and he's not good at handling his financial affairs. Maybe he can be led down a bad path if you confuse him or catch him at the wrong time of the day. Maybe you need someone, you know, in charge of those things. But you're living fine, you're in relatively good health. You know, you have a daughter that comes by and picks you up and takes you to your doctor's appointments, or you're good at using public transportation or Uber. Maybe you don't need everything decided upon you. So I can tell you that's what you hope when you go in these cases. You hope that they get to manage some of their affairs, because quite honestly, people change when you tell them they can't make certain decisions and things like that. And it's always my hope that they can at least hold on to something. And we're about to go through all these rights that can be removed, and you can see why you like to leave something. So let's just look generally at some of the rights that can be removed and just see how all-encompassing it can be. I mean, you lose the right to marry, to vote, to personally apply for government benefits, to have a driver's license, to travel, to seek or retain employment. From practitioners, and if there's any practitioners out there listening, you know, one of the kind of the hallmarks is very rarely will a judge check off the to vote. They can lose, a lot of people lose capacity in all respects, and they'll keep it in the right to vote. And I think that says a lot. And I think that the folks like it too, that they retain that right. Only in the, you know, the extreme where they really have lost, you know, the ability to understand what's going on around them, do usually the examiners find that they should lose the right to vote, or the judge. Now, the way the judge decides this is evidence, and the basic evidence is when you file an incapacity proceeding, there's an examining committee of 3 professionals. One has to be a doctor, and they go out and examine, and they give a report to the judge. You can have other experts if you like. You can introduce evidence. The alleged incapacitated person can testify, which can be very persuasive if they come across very capable. Family members, witnesses, professionals that are involved with the incapacitated person can also testify. All evidence, all that taken in, and the judge makes the decision on what kind of guardianship and what the limits of the guardianship will be, if any. And it should be noted that as part of that, that seeking the least restrictive means possible, a judge can find someone incapacitated and find that they have documents in place that's sufficient to disregard a guardian. For example, if they have a good durable power of attorney, the person that's handling the financial affairs through that durable power of attorney seems to be doing a good job, is trustworthy, they have a healthcare surrogate for their spouse or their child, and that seems to be working, the judge may just say, I don't think guardianship's needed, you know, and that things are being handled through these other affairs. That's part of the pre-planning we'll talk about later. Obviously, if you don't have pre-planning in place, the judge can't consider that. So we looked at what rights can be removed from a ward. These are rights that can be removed and then delegated to a guardian, and you don't need a court order. Those are to do these things. Those are the rights to contract, the rights to sue and defend lawsuits, to apply for government benefits, to manage property or to make gifts and disposition of property, to determine the residence of the ward, to consent to medical and mental health treatment, and to make decisions about his or her social environment or other social aspects of his or her life, meaning the ward's life. Now, I want you to think about that. That's pretty significant. You can determine where a person is going to live, what kind of medical procedures they have to consent to or not consent to. People always think of guardians managing money and managing your property, and granted, that's an extreme power. But as a person, I think one of the most personal losses of liberty can be losing your right just to say where I live and who's going to take care of me and what test I'm going to consent to at the doctor's. So I think it's important to review these. We kind of go through them in a list sometimes, very offhandedly, but really realize what kind of power a guardian has, because not only have these rights been removed from you, they're being given automatically to the guardian, and that's something to consider when deciding who a guardian should be. Okay, what do guardians need court authority to do? It's limited to 5 areas, and they're pretty extreme areas. To commit the ward to a facility or an institution, for experimental medical procedures, to dissolve a marriage, to consent to termination of a ward's parental rights, or consent to abortion or sterilization. Those are considered pretty extraordinary, and you always need a court order to approve those. So as I said, this is our background and our introduction into guardianship to go over. But let's start talking about what we're here about to focus on today, and that's professional guardians. When someone's been declared incapacitated, and there's been declared a need to have a guardian, in a lot of cases, a next of kin, the person that maybe initiated the proceeding, they are oftentimes appointed. They will not qualify if they have a felony or they have been convicted of a crime that involves, could be construed as abuse. That disqualifies you. There's other considerations the court obviously can take into consideration, if you're fit to do these things, if you have the time, and things like that. Being a resident of Florida is not a requirement if you're in that next of kin category that's set up under the statute. And not even that, it goes a little beyond next of kin, it goes to relatives primarily. But you need to be able to show that you can demonstrate that you can conduct your duties from a distance. In today's age, banking for someone, handling someone's financial affairs from a distance isn't hard at all. Usually guardians aren't the primary caregivers, and they hire people to do things like that, so that can be done remotely. The key is you got to be in and you got to oversee that, because you're responsible for the people that you hire and have there, and you need to be able to make at least a certain regular visit on a certain interim, and make sure that you can report to the court all as well. You're also to the extent it's possible, any guardian is supposed to get input from the ward and supposed to incorporate that to the extent it's reasonably possible. When you're dealing with incapacitated persons, obviously sometimes it's not the easiest thing to do to determine if what they're telling you is really what they want, or if they're confused or delusional. But if it's a reasonable request, it seems to bring them happiness, or some kind of sense of control, and it's not to their detriment. I think the policies are in favor of including that, and the rules encourage guardians to communicate with the wards as much as possible and let them know what's going on. So let's now start focusing on professionals. How about if you don't have someone that's a relative or close friend who's willing to serve or able to serve, or didn't get notice and even know that you need this, or maybe in a context of when you have 2 children and the children do not get along and they're accusing each other of having bad motives, and the judge can see where this is going. If he appoints one, the other one's going to attack everything they do, and vice versa. these are the contexts where you usually find yourself with the court deciding whether he's going to appoint a professional guardian. What is a professional guardian? Professional guardians are just what they are. They do this for a living. They have multiple wards usually, and it's become quite common to not just be a person, but have a staff under that person, under that guardian, to be working under a company with staff members and things of that sort. They have to register, Section 744.1083 Florida statutes. There's a registration process, and there's a small fee of $1,000. They have to fill out forms, submit to background checks, things of that sort. The background check is hoping to ward out anybody or weed out anybody who might be potentially an unsafe or abusive guardian. And then they're regulated, and they have to provide supplemental information when requested. They must receive training, a certain minimum amount of hours. Even their credit history is investigated. So if you're thinking what's the difference between them and my daughter, it's basically someone who's done this before. They've submitted to a much more detailed background check than a personal guardian will when they apply to be if you're applied to be a ward's guardian. For example, if your daughter applies, she'll get a background check, but not a credit history check. She may have some minimum education requirements, but not that of a professional guardian level. So in theory, they should be more experienced at this and should be more effective and efficient at doing some of the duties of a guardian. And they're required to post a bond of $50,000 blanket bond. So let's look at what could be the pros and cons of a professional versus having what I call a personal guardian, which would just be a friend or a relative that would be serving. Well, some of the pros I alluded to before. You have a neutral party. If you have conflicts in the family where the brother's going to question everything a sister does and the sister's going to question everything a brother does, let's bring in a neutral party. They have, it's hard to disagree that a neutral party has bad motives. So that can eradicate that potential problem and eradicate, a potential headache for not just the judge, but there's going to be additional costs associated with handling conflicts between siblings, and if they're the one of them is the guardian or some other party, some other relative or group of relatives or friends of the wards that have an antagonistic kind of relationship and they're adversarial. You want to this is a way to kind of end around that and probably save the ward some money in the end and not having a lot of petty arguments brought before the judge. So anytime a judge starts seeing that kind of dynamic, a professional guardian might be considered. And some of the other pros, as I said, they have staff, they've had more extensive training. So you usually have a lot of experience with handling wards affairs. They usually have, experience with applying for governmental benefits, making Medicaid applications. A layperson, those things can get pretty tedious and you can get lost in the weeds. And oftentimes these folks have done it. They know the people to contact, they know the forms, and they can do it in a very efficient manner. And then in theory, at least they should lack conflict of interest. Their only interest should be that of the wards and what's in the best interest of the ward. They don't stand to inherit. They don't stand to, get anything other than their compensation from this ward. So in theory, they should lack conflicts of interest, unlike anybody who's a personal friend or relative of a ward is more likely to have a relationship and some kind of potential conflict of interest. It's just natural. So what are the cons? They're expensive. Their fees are substantial. I did a little research, and Florida is actually pretty high on guardianship compensation. The average guardian and professional guardian in the state of Florida, according to a ZipRecruiter article that was just published, is just over $42,362. Florida ranks 49 out of 50 in the highest paid to guardians. It looked like they said most of the states pay somewhere between, or the average is somewhere between $21,000 and $50,000. So if that gives you some perspective. What are they allowed to receive? They're allowed to receive a reasonable compensation, normally not to exceed 5% of the income of the ward, section 744.641 Florida statutes, but there's extraordinary things that a guardian may do. They may have to do things that like run a business, help run a business, the ward had a business and gotta oversee that, or I gotta get it ready for sale, or property I have to get ready for sale. Things like that are considered extraordinary, and those get paid a reasonable hourly rate to be determined and approved by the judge. So when you ask what they make on any one guardianship, it's gonna vary depending on the nature of the assets, nature of the work that was required by any particular case. What are some other cons? A lack of empathy sometimes. Obviously relatives and loved ones are going to have an understanding of an individual situation, their personality, that a professional guardian probably won't. A child's going to understand if their father's being grouchy or downright, sounds abusive. They might know that's their reaction to being fearful, or feeling uncertain, and they may have be able to communicate in a way that the guardian's just never going to be able to communicate because they didn't know this person before they were in this situation. And probably the con that we're going to be looking at today, and what comes to mind, is the potential for abuse. It shouldn't be. There's nothing I can point to in the statute that says a professional guardian gets more of a less of a scrutiny than a regular person, a lay person who's serving as a guardian. There's nothing in the statutes to provide for that. In either case, the judge is the ultimate, scorekeeper, the ultimate guardian, if you will, of the guardians, to overlook and oversee and make sure that things are going as they should. But I don't think it's unfair to say that probably in practice, and especially with professional guardians that have a certain reputation, that there's a tendency to give them a benefit of the doubt, maybe. And maybe that's why when we look at abuse cases, even though they can be in the cases of a personal person or lay person serving as a guardian, in the high majority is in the context of professional guardians. And it makes sense. They know the system. They know what would send up red flags and things of that sort, and they probably have an advantage in that scenario. Now, there's nothing in today's presentation that I mean to suggest that all professional guardians are abusive or are skirting rules or things of that sort. I do think, thank goodness, it's still the exception to the rule, but it would be, just pure ignorant to say that these things don't happen. I mean, how the Rebecca Fearley case got to where it was, how we get cases that end up on exposés about how people lose their whole, that were financially secure and they end up wards of the state. Those can't be ignored, and it's always a good thing to try to be aware of these and try to fix any loopholes that may allow them, and to re-examine what we're doing as professionals and practitioners to see what we can do to make sure these things do not happen. And one of the best ways, I think, is the pre-planning that I had mentioned before that we'll be getting into shortly. So before we get into what we can do to avoid a professional guardian, if that's not what you want, let's look at just some issues with liabilities and damages so that you can kind of understand what potentially are you looking at if a guardian goes wayward or breaches their duty and causes a damage. Now, you got to remember, in this context, we're presuming guardianships have, the wards have relatives, next of kin, people who actually have an interest in the guardianship, who are watching things and are filing things with the court saying, I don't think this is right. I don't think they should be selling this for that price. I don't think this is a good place, and questioning things. I would hazard a guess a great deal of guardianships do not have that kind of person. That's why they ended up with a professional guardian, because there was no one else who was willing to serve or was close enough to the family or anything like that would be interested. So when you don't have someone else pushing the issue, it's only on the judge and the monitors that monitor this from the judiciary side that can look and find where they've been damaged and things of that sort. So kind of keep that in mind. It's a process that requires its own the court to monitor it solely without a push from an adversarial party, because there might not be an adversarial party to the guardian if there's no other persons that are interested in this ward's life. So we look at section 744, 446, Florida statutes. That's the statute that says a guardian can't serve or do anything during the course of their guardianship that puts them in a conflict of interest. For example, if you're going to sell a ward's property, don't hire your daughter as the real estate agent. Don't sell to a friend. Don't sell to a relative. Certainly, if for whatever reason a friend of yours is the best and highest offer, you must get, and so you think it's still in the best interest, you must get court approval for that and disclose all those things. Anything that a guardian does that was in a conflict of interest can be voided and can be deemed a breach of fiduciary duty. Guardian has to provide plans and accountings, and this is true for professionals or personal guardians. And the plans advise the judge what is the plan, the personal plan for the guardian. Where is he going to live? What kind of care? Who's his doctors? Who's he been seeing? What kind of medicines, things of that is he taking? What is the plan for the future or the next year to handle any needs he has or she has as the ward? And then accountings are the financial disclosures, and those go through every year, and they're monitored and reviewed by judicial staff and the judge, and approved, or if there's a question, there's a hearing on it, and that has to be resolved. And then there's an item called a judicial interim review that's permitted under Florida statutes. And I'm a fan of this. But this only works if you have another party that's interested in what's going on in the guardianships. But at any time you can use this. An interested party can file a petition questioning something that the guardian is doing, questioning whether it's within the plan, within the scope of the authority granted to the guardian, or just in the best interest. And the judge can review this and determine if some corrective action needs to be made. So I encourage practitioners and interested parties to use that when necessary. Now remember, you have to use it in good faith. You can't use it harassive. If you're found to be using it, raising issues in bad faith with no real basis, you can be hit with attorney's fees and costs. Now, the Office of Public Professional Guardianship, they're the entity that oversees, or professional guardians, I'm sorry, Office of Public Professional Guardians in Tallahassee. They're the office that oversees guardians, and that are in charge of regulating them, making sure that they stay, that they comply with all the registration requirements and things like that. There's also the office of that you make complaints to, and I just put a link there for an article that talks about the, that there's not that it's not very staffed. It's not staffed very well, and complaints go unanswered or not sufficient attention given to them. They also, but this article went into that when there was some shakeup after some questions came to be asked about whether guardianship abuse is not being properly identified. There was a big shakeup up there at the Office of Public Professional Guardians. I think where 5 key directors immediately resigned. So I thought that was interesting, and I thought it's a good idea to keep that office in mind. I think it's changed, and I think this shows us there's a desire there to change things up and give more attention. Obviously, as long as they're constrained by budget restraints and they don't have the money necessary to fully investigate all the complaints, their effectiveness will be limited. But I think there's definitely a concerted effort to make sure that they're paying attention more to professional guardians. Moving on to the next slide. A moment. So with regards to damages, if you have damages that fall from any of these things, you do have the bond that you can address. You can it's always a blanket $50,000 unless a judge is somehow convinced to increase the bond. I've never seen that happen personally of a professional guardian. They sometimes have professional or E&O insurance, and they can be disgorged their fees and things of that sort if to pay back any damage done. All right, so now let's circle back to what we've been leading up to. presuming that you have a client or you work with people or you are a person who wants to avoid getting in the situation where you have a professional guardian, you have someone who's a stranger handling your affairs, who didn't know you before, never spoke to you, never really could understand what it is, how you'd like to live your last years, or what you would like to see happen. And in the case of that you become incapacitated, who's never had those kind of conversations with you. I would think that's probably a majority of people want to avoid that if practical and possible, and especially when it comes to their personal affairs. And so how can we help our clients, or how can we help ourselves if that's our goal? Well, pre-planning is the biggest thing that we can do. In Florida, you can do what they call a pre-need guardianship declaration. It's governed under section 744.3045, and it's a standard form, and it basically, you declare who you would like to be your guardian in the case of any kind of incapacity proceeding, and you can even name a backup and things of that sort. Now, and then it's filed in the court in the county that you reside in at that time. Now that might be one of the pitfalls, if you will, because what happens, people do those, and in the prime of their planning, maybe in their 30s, 40s, they're filed in the county they live in at that time. Fast forward 20 or 30 years, they may not live in that county anymore. They may have been moved to a neighboring county to be in a facility or a hospital, and then technically, so when the guardianship's filed, it's filed in a different county, and nobody knows of the pre-need guardianship. So if you're going to have those, it's good to keep those up to date. It's good to make sure that your loved ones, your professional advisors, keep copies. So if something ever happens, someone can produce that to a court that may not be in the county you resided in at the time you filed, and can present that and let your wishes be known. And what I would recommend, I think most practitioners recommend, is when you name people pre-need guardians, that's all well and good, but you need to have a conversation with them. You need to call this person. It's never a pleasant conversation, but it's just in the case, if something happens later on, I like to see myself staying at home as long as possible, paying for caregivers. Maybe that's your preference, as opposed to living in a home or one of these group places, or maybe it's just the opposite. You see yourself, you'd rather stay among groups, stay active, have activities. Those are things you can express. You can express how maybe there's certain assets you don't want sold unless absolutely, in the least of circumstances, because you want to see maybe your home go to your children or something like that, and you'd like to see that be the last asset. Maybe you want your business to continue if something happens to you. You don't want it sold. Your preference is to have it continued so that you can be inherited by your children, if at all possible. Those are things you can talk to a pre-need guardian about, and they'll have a better idea of what it is you want, because you may not be in a position to express that later on. Maybe you want things to, maybe if you become incapacitated, you want things to be more private, you want limitation on visitors, and just any kind of preference like that. You have a chance to speak to that with a pre-need guardian. You can put this all in writing, by the way. Florida doesn't have a mechanism to give directions to a guardian that is binding or anything of that sort, but I think anybody who you would trust to name in a pre-need guardian would be respectful of any wishes that you express, whether in writing or verbally, and that's why I would encourage it. That gives you an opportunity to have a voice while you still can. And hopefully it helps you make sure you're choosing the right person. If they express didn't realize it would be that involved, or they don't think this is a job for them, it's better to know that now than later. What else can you do? Part is pre-planning. Have good professionals around you, good professional advisors, and I don't just say that as because I'm an attorney. Have people you can trust, who know you, who you have a relationship with. I've been called upon when guardianships have been filed involving former clients, and I'm able to give information that I think is helpful. And I think it's important that the people you trust, which hopefully are your professional advisors that you have around you, that they have information that they can share. Your accountants, your financial advisors will have financial information that will be helpful to any guardian. And hopefully your legal advisors have an idea, who've done your estate plan or done other planning with you, business planning, they might have a better idea of some things. You can also, as part of that business planning, by the way, if you do have a business, you can do succession planning as part of your business plan. You can have a plan in place if you become incapacitated, who takes over, who votes your shares, whomever. That can be automatic and wouldn't involve your guardian because it's already been predetermined pre-incapacity. So in that respect, I encourage you to meet with your lawyer, any other financial advisors you may have, and discuss this. Discuss in this day and age with guardianships, becoming more and more common. I have to see the reality that one day maybe I'll be subject to that. What do I want to put in place beforehand so that a guardian's not having to deal with that or making decisions that maybe I wouldn't agree with? And so that's a way to do some pre-planning as well. When things change, let your attorneys know. When you move, let them know. When maybe a spouse passes away who was your pre-need guardian selection, let them know. When you get maybe some diagnoses that maybe put you in a state of concern, let people know. While I can understand not wanting to face certain things or deal with certain things, pre-planning things like this can keep you from having a nightmare situation. Now, having a nightmare situation in guardianship is still very rare. It's not the likely event, but it can happen. And that was some of the things that I alluded to before, and we can get into here shortly, talking about what happens when things go bad. And again, I don't say this to scare you or make you think that's what's going to certainly happen. I say that because I think when you hear stories, when you start seeing that there's lapses in the rules that can allow for abuse if you have the wrong people involved, I think it's important that people know about that, and they make a decision for themselves that they'd like to do some planning to try to avoid that. And I personally think there should be more attention brought to this issue, especially in light of what's happened recently here in Orange County. And I'm still working on trying to get that next slide up. But when it does, we'll talk about the Rebecca Fearley matter. Just briefly, it's been well televised, but she was a professional guardian in Central Florida area, had a high number of guardianships, and come to find out, our local judge at the time that was handling guardianships in Orange County, Judge Thorpe, come to realize she was signing do not resuscitate orders without seeking family approval or court approval. And there were some questions about the appropriateness of that, and one in particular, and that's been a well televised case that the family contends that the man died wrongfully. He wanted to be resuscitated. His family wanted that, and that it's not the wrongdoing on the part of this guardianship, or at least that's what's alleged. Papers have been full of stories about, come to find out, she had a relationship, it seems like, with Advent Health, or at least a very unusual amount of billing that went through Advent Health. I think the number of 4 million was thrown around. That would seem very unusual. So now that she's been investigated, the idea that's come out is that sometimes these professional guardians get they run things through their accountings, and things don't pull a red flag necessarily, but then when you look at it in totality, you see that there's a problem here. So I think you might see some changes to the law based on that. That case also brought back the question of trolling in Florida. Trolling is a common term that was used and still used, but it was recognized a few years ago by the legislature that there is a practice of professional guardians trolling certain places to find potential clients. Going to nursing homes, having coffees, meet and greets, having relationships with people at hospitals to give them a call if there's an elderly person with wealth that happens to be there and there's no family members, or having a relationship with nursing homes, similarly the same way. It's any activity where the guardian goes out and essentially solicits business or tries to get referrals for business and tries to directly communicate with people who may be incapacitated in the hopes of being their guardian. I mean, trolling, obviously in of itself has a bad connotation. I personally think it's certainly in poor taste at the very least, and it certainly calls questions of conflicts of interest and things, but unfortunately, it's still legal. The legislature did propose a bill that got knocked down last year to do away with trolling, or try to do away with it, and most of it got gutted, and that's unfortunate. But I think you might see that come back now that these kind of cases have been highlighted. One of the other things I was highlighting, I still don't have the right slide up because it's not cooperating with me, but was that Jose that just came out in the Netflix streaming series called Dirty Money, where they investigate certain areas of the economy and society where there's exploitation and things of that sort. And it was called Guardians Inc. And it just came out a few weeks ago, I think. And I thought it was a very interesting thing. And I watched it thinking it would be sensationalized and, for entertainment value, but I didn't find it that way, to be honest. I found it unfortunately, I heard a lot of things that I could see happening here in Florida. Now, the cases they looked at, some of the cases they looked at were like one in New York, or I think it was actually New Jersey, where an elderly person one day gets a knock on his door. He has a lot of rental properties, and someone, wanting to help him out, help him with his properties. And, next thing he knows, he signed something, consenting to be examined and to be, and later determined to be incapacitated. And all his properties have been sold, and he hasn't seen a dime of it, and he doesn't have any communication with his so-called professional guardians. Then there was one in Texas where, there's these professional guardians who get a lot of cases. They charge, what we would probably consider substantial fees. They get a percentage of any assets they sell automatically, which encourages selling of assets, even when it might not be in the ward's best interest. And they looked at some of those cases, and they even saw cases where it was a lay person, it was a cousin or a niece that was the guardian, but they had professionals around them that helped them exploit that person, and that they're being investigated for potential abuse now. And at least that was the allegation. So when you look at those, I'd like to say I watched that and thinking this can never happen in Florida, but I can't say for certain I would say that. I think it can happen if you have unscrupulous guardians, more importantly, unscrupulous advisors to the guardians. Remember, guardians in Florida have attorneys, and hopefully if they have scrupulous attorneys around them, it'll be harder for them to do these things. And if you have judges that don't take their oversight functions seriously, I think every guardian should be scrutinized with equality, and I think we should encourage that as practitioners of the bar and as people who appear before the judges, that we should encourage scrutiny. A guardian should never be afraid to answer some questions. They're given a most trusted position. They're people that can't usually even understand what's going on, and they can't even sometimes articulate what's wrong or what's going on. And if you're putting care of those persons, people you don't even have a professional relationship with, just strictly a professional business relationship with, there always needs to be oversight, and it can't always fall to the relatives of the ward, because in a lot of cases they don't have relatives that are that close to them that would do that, and that would spend monies and fees to do that. So I think as members of the bar, practitioners, advisors, as people who love other people that might be in this position one day, I think it behooves all of us to think about these issues and meet with advisors and do as much pre-planning as we can. And when these things happen, to pay attention, and if we see any kind of red flags, to report it, to bring a voice to it. Those are all things I think we can do. I think you'll see some changes in the laws in the coming years that will try to shore up some of these shortfalls in our statutes that we've discussed today. And I suspect that's going to be the trend and continue to be the trend as guardianships are going to continue to grow. The number of guardianships are going to continue to grow, because of nothing else, because of the elderly population is exploding due to the baby boomers coming of age. So for all these reasons, I hope this has been helpful. I hope it's given you an idea of what we're always looking at in these professional and guardianship situations, why people have professional guardians in certain situations, why you even consider to have one in certain situations, and what you should be looking at when you do have one of these folks in place. If you have any questions, now would be a good time. I've got the questions up here for them up for me. If not, feel free to send it afterwards or email me. And I'm still trying to bring up the screen that's supposed to have my information. There we go. Forster Bowman is the law firm. My email address is phillips@fbl-law.com. Feel free to email me any questions we didn't get to today. I think we're working on some CLE credit for this, and if we have that, we'll circulate that to all the attendees as well. Okay, none? All right, well, thank you for your time. Thank you for joining us today. Again, please feel free to contact me if there's any questions I can answer for you. Take care.